Give me a reaction button by raising your hand. Let me know that you're ready. All right, Mr. McLaughlin, what do you have?
I have two cases. The first one is Fifth Third Bank versus Salinas, and we're asking that it be retained.
All right. This is CL 170298H, Fifth Third Bank versus Pedro Salinas and Juan Salinas. Status conference hearing reset from January 24th. And you're asking that this case be retained on the docket. Have you had any communication with the Salinas family?
Not to my knowledge, sir.
Okay, I have a note here that the respondents testified that their vehicle was stolen and was not repossessed. Is Mr.
That is right. That was in our discussion here in court, and they were supposed to go talk to their insurance company and figure out whether or not they could file a claim. I think in this particular case, they had said that they were afraid to file the claim because it was stolen across the border and somebody had threatened to do something from the cartel.
Oh, okay. All right. Is Pedro Salinas or Juan Salinas present? Pedro Salinas, Juan Salinas, if you're on mute, please unmute yourself. Pedro Salinas, Juan Salinas. All right. Mr. Aguilar doesn't seem to be logged on either. You're just asking for some additional time. Let's give this a DCC.
Okay. I have one other case today, sir.
Give me one second. Give me 1 second while I do that. Give you a DCC.
April 5th.
April 5th, 2022 at 3 p.m. Right. We had some individuals that just walked in. I want to make sure that they're not Pedro Salinas or Juan Salinas. Eddie, can you? All right, and the next case you've got
is Unifund CCR versus Juan Salazar.
All right, that's CL 196638H. Unifund CCR LLC versus Juan Salazar. Juan Salazar, is Juan Salazar present? If you're on mute, please unmute yourself. Juan Salazar. Last time we were here, Juan Salazar was present via Zoom. And I think Mr. Rodriguez, who was representing Unifund last time we were here, asked for some additional time to try to work out the case with the defendant.
Right. And to my knowledge, it hasn't been worked out. So we'd like to go ahead and set a bench trial date at least 60 days out. And hopefully we can settle it before that.
All right, May 25th, 2022 at 9:30.
Thank you, sir.
All right, anything else?
No, sir, that's all I have today.
Thank you so much. Let me move on to Ms. Vale. F5473-218 in the matter of the marriage of Hermelo Mancia and Maria Arellano.
Yes, Your Honor, this is Darlene Vale. I represent the respondent, Your Honor, on this matter. I don't know if Della Fe is on there. I represent Hermelo Mancia, Your Honor, the petitioner. And I don't know if Della Fe's on already or not.
Yes, she is.
Yes, I am,
Okay.
Judge. I'm
Your
here.
Honor, I guess-
My client is also present.
My client is present as well, Your Honor. I guess we need some sort of direction from you. We went to the AGs. They're gonna provide the test, but we haven't gotten any word from them. We were trying to get the genetic test for this couple done for the children to find out whether his children or not. We still have temporary orders pending, Your Honor. It's gonna be highly contested. I don't know if the court requires us to go to mediation or not. Your Honor, we're really here to take direction from the court, but I anticipate that it'll be at least a 2 to 3 hour hearing.
All right, Ms. Bettis?
Yes, Your Honor. As far as mediation, I would prefer that we don't go to mediation. My client is indigent and really can't afford the cost of a mediation. I think that if we can maybe do an informal mediation amongst the parties, we can try to resolve a lot of the issues for temporary orders. I think we're just doing visitation and child support, that kind of thing. But I think more importantly, in order to resolve the temporary order issues, we needed to have those DNA test results done so that we can know for sure which children do belong to Mr. Mancia. My client indicates all of them, but I guess there's some questions. So
what's the holdup on the DNA testing?
For some reason, Your Honor, the AG just hasn't given us a date.
my suggestion, Judge, was that we maybe order the AG's office to enter into this case and maybe set it for another hearing in a couple of weeks so that we can, I guess, get a date from them as to when the DNA testing will be done. But that's just my suggestion.
Your Honor, this is my suggestion. Irregardless of whether or not, I think there are going to be custodial issues between these parents. So there's going to be expenses involved. My client certainly doesn't have any more money than she does, but he does work. He is willing to go ahead and do whatever the court orders. If we have to, Your Honor, we have to pay for mediation. I have no problem in engaging in informal mediation, but sometimes it doesn't work. And so I just need to kind of a guideline from the court is if we need to do mediation, when we need to do it, Your Honor, because I'm going to be filing probably other motions as well on this matter, Your Honor. And there are not just custodial issues, there's property issues involved in this case, Your Honor. It is fairly complex. It's like a little law school exam. So in any case, Your Honor, I don't know whether the court is going to have time periods today. The court wants to send us to go. I have no problem engaging in doing informal mediation with Ms. De La Fe Perez, but I think none of that has happened. We've been on the case for a while. That's what it is.
So I'm getting a note from Ms. Ledesma from the Attorney General's office, who is advising me, I guess, that says a case would need to be opened via referral or application with the Attorney General's office. Has that been done?
Yes,
My
Judge.
understanding is yes, Judge.
Ms. Vale sent a letter to them several weeks ago, maybe about 3 weeks ago, and I think she got a response back from them that they agreed to enter into the case. So I don't know if they just didn't get notice to be here today, or maybe Ms. Ledesma has some information on that. But I think they just need to get notice to show up so that we can engage
yes,
with
Your Honor,
them.
they both went to go open up the case. My client did, and
Yeah.
so did Mrs.
We sent a letter too.
And so do you happen to have an OAG case number?
No, Judge, I do not.
No, Judge.
Ms. Ledesma, I see you there. Can you offer some insight?
Well, Your Honor, I'm not here on this case. I did not have notice of this case, but if they could provide an OAG case number, or what is the current cause number?
We have a current cause number from this cause, which is F5473-12-8. We do
21.
not have an OAG number.
Yeah, it's 5473-21-8.
I'll go ahead and look it up, Judge.
If you could just offer some insight. I know you're not prepared for this case, but just some insight as to what.
Or maybe you could give us a date that they need to show up to go take the tests with the IDs.
Is this a SAPSR or a divorce?
Divorce.
It's a divorce.
So I'm not showing this case on our system, Your Honor. It could be that if we do not have the referral or an application on file, even if a letter was sent to our office, we do not have a case open. Let me try with the party name. If I could have dad's last name and first name.
Mancia is the last name. Hermelo, Hermelo is the first name.
And mom's name?
Mom's name is Maria Denise Arellano. and Denny's is spelled Deny's.
I do have, I apologize, Judge. I do have a Texas Attorney General case number. And I have my client's member ID number, which was issued on February the 9th, 2022.
Judge,
If that,
Ward,
would that be helpful?
recall the case to give you a moment to look it up?
Sure, no problem. Thank you.
Thank you, Judge.
Why don't I do this? Why don't I know that you're not on this case, Ms. Ledesma, but it might be best if I do this. I'm gonna put you all in a breakout room so y'all can exchange all that information and you don't have to be guessing. And that way you can do it apart and quietly. And let me put Ms. Darlene Vale, Ms. Bettis, and I will put Ms. Ledesma as well.
And Judge, before going in, yesterday afternoon, we received an email on a different cost set on the court's docket for today.
Okay.
We did not have prior formal notice. I did want to make an announcement on that one. It's F3768-218.
All right, in the matter of the marriage of Noe Garza and Crystal Gongora. All right, and the office, you're saying that you did not get notice of it?
No, Your Honor, we received an email yesterday afternoon. So there is a pending OAG cause number that's F3656-218. So there is a prior order under that cause. We would need to file a first amended pleading as well as a motion to consolidate into the divorce cause, Your Honor.
Okay, so you're just gonna need some time on that case, correct?
Correct, Your Honor. That way we can file the appropriate pleadings.
All right, and you think 30 days would be enough time?
It should be, Your Honor.
Let me go ahead and give you a 30-day reset on that one. April 27th, 2022 at 9:30.
Thank you, Your Honor.
Ms. Gongora, this case, your case is going to get reset. I see you there. Reset for April 27th, so the Attorney General's office can take care of some paperwork that they need to do.
Okay.
Your Honor,
Yes.
I had a question. Is there any way we could just move forward with the divorce? I mean, I know the child support is a different thing, but I mean, I just really need to get this divorce over with.
Okay, and I suspect that you are Mr. Noe Garza.
Yes, sir.
Okay. Well, that's a question of, you know, I'm assuming you guys are pro se. That's a question of whether or not y'all can resolve most of your issues. Have y'all tried to communicate to see whether or not y'all can resolve your issues?
As in what?
Well, as in, I mean, again, this is the problem with pro se litigants. You don't know what you don't know, right? You want to finalize it, but you don't know that I need a final decree of divorce. You don't know how to prove it up. And you come here asking me to do this for you when I can't do it for you because I'm a judge and not your lawyer. So the question is, if you want to finalize it, my suggestion would be retain an attorney, have them prepare a final decree of divorce, exchange that with Ms. Gongora, see if all issues can get resolved, bring it to me, and I can take care of it on any day of the week, on a Monday or Wednesday of any week. I can take care of it for you.
So the final decree, it was already made, no? I had turned in that final decree. It's been on there.
So you all, my understanding is that there was no issue with the child support issue is what is remaining. You all, that
Yes.
child support issue was never resolved. And
Yes,
that's
Your
what
Honor.
I need.
Oh,
And that's why the Attorney General's office is involved.
okay. So there's no way we could just get this over with.
Ms. Ledesma, how much time do you need? Do you need less time so that all these cases can get resolved? I mean, I don't mind giving them less time, but I'm trying to give you as much time as you need.
Yes, Your Honor. Our office prior to the divorce being filed a petition to establish on the third child. We do not have a copy of the marriage license. So we would need that information from one of the parties. I'm not sure if the marriage occurred in Hidalgo or Harris County. This was a transfer from Harris. In addition to that, there are arrears on the case that would need to be addressed. In looking at the proposed final divorce decree, there is no reference to those amounts. So if we could have a minimum, Your Honor, of 2 weeks, or if the parties could be placed in a breakout room and I could speak to them and try to obtain more information from them.
Okay, let me do that. Let me put you in a breakout room with them first. And that way you can communicate with them because this is your case and you are here on it. In the other case, you're just doing it as a courtesy. So let me go ahead and do that. Now, my problem is that I'm trying to place people in a breakout room and having some difficulty doing that. Okay, so let me try again. I'm going to put Ms. Góngora, iPhone, and Ms. Ledesma. Let me put you in a breakout room. Y'all, please accept the invitation. When you're done, please come right back. Give me information on what y'all came up with. Ms. Vale, Ms. Pettis, hang tight, and then I'll get Ms. Ledesma in a breakout room with you all.
Okay, that's fine, Your Honor.
Perfect. Let me move over to Mr. Aguilar. Mr. Aguilar, I may have already called your case. You're here on the CL 170298H, Fifth Third Bank versus Pedro Salinas and Juan Salinas. They asked for this case to be given a DCC. I gave it a DCC date of April the 5th at 3 o'clock. Do you have any new information or any objection to that?
Well, yeah, on this one, Your Honor, I did see in 2019, I had filed a motion to withdraw. I do believe it was this case comes from out of court 4 and might have been transferred out here in between that time frame. And I just filed an order yesterday because I noticed that I kept receiving notification on this case, but I was at least under the impression that I had already been not the lawyer since 2019 when I had submitted the motion. And my clients were in agreement for back then for me to withdraw on the case. And I think they keep operating and moving forward with the case without me. But I guess the order hasn't been formally officially signed, Your Honor.
All right, the clerk will request that from the clerk so that I can sign off on that today.
Thank you, Your Honor.
You'll be granted your withdrawal.
Thank you, Your Honor. May I be excused?
Your excuse, thank you.
Your Honor, was that all? I was told to reappear on that Salinas case.
Yeah, that was the reason for that, Mr. McLaughlin.
Okay.
They are present.
So they are present here. Let me have them go to the back and see if they have anything to add, but otherwise I'm going to give it a new DCC.
Okay.
They should be walking to the computer that we have set up in our jury room so that there won't be any interference with our audio.
Okay.
They'll be there in about 5 seconds. Okay, we have Pedro Salinas and Juan Salinas. My understanding, Mr. Salinas, to both of you is that last time we were here, information was given to the court that the vehicle had been stolen and not repossessed, but we needed to get some information about that. Were you able to acquire that information?
Everything's here.
Okay. Mr. McLaughlin, what's the best way that we can maybe get you a copy of that information? I have not seen it. I don't know what it is, but I think the first step is to get that information to you.
I can give you my fax number. That would be the quickest way.
Okay. Go ahead.
512-857-8957.
All right. We will make a copy of that information that the Salinas family has, and we will fax that over to you today. In the meanwhile, I'm going to go ahead and continue with that DCC that we have for 4/5, April 5th at 3 o'clock. That's a telephonic DCC. Pedro
April
Salinas and
5th.
Juan, yes, April 5th at 3 o'clock. And so Pedro Salinas and Juan Salinas will give you information. My staff will give you information on how to go about, calling in and being a part of that DCC.
Okay.
All right. Anything else?
No, sir.
All right. Thank you so much. We'll get that information out to you here shortly, and then we'll get a copy and we'll give the Salinas family some information on the DCC.
May I be excused?
You're excused. Thank you.
Thank
Ms.
you.
Cowan, what do you have?
Good morning, Your Honor. Here on cause number 21-3222, Eladima Garza versus State Farm Lloyds. Mr. McAllen is also present.
Good morning, Your Honor. William McAllen on behalf of the plaintiff.
We're here for a status hearing, Your Honor. This matter was initiated in September by Mr. McAllen for purposes of the appointment of an umpire in a residential property appraisal. The appraisers were able to reach an agreement in November, so no umpire was ever needed. An award was rendered. State Farm has paid that award. Mr. McAllen has made a post-appraisal demand of my client, which was rejected. We were here in September for a status conference in January for a status conference because there is nothing pending before the court. And the court gave Mr. McAllen some additional time to do what he wanted to do. And there is still no matter pending before the court. That's why we're here.
Yes, Your Honor. Yeah, we had made some, trying to see if we can negotiate the post appraisal, the fees and stuff like that. And they did indicate that they weren't willing to accept my offer. So I just, let me look at the file, Your Honor. Could I have maybe 30 days to see what we need to do on this case? If we can either resolve it or we need to proceed with amending the petition. Usually I've been able to resolve them, but some of these do get a little sticky. So let me, if the court would afford me a little time to see what needs to get done on this case in particular.
Okay, Ms. Cowan, any response to his request?
No, Your Honor, other than he's had since November. And he's already approached us about asking for additional settlement funds, and we have rejected it. So I just would like a time certain by which we're going one way or the other. Because I don't
need much time, Your Honor. I probably just have to amend my petition and to add that new cause of action of the post appraisal. The law is pretty clear that when there is an appraisal award that the homeowner can try to recoup some of the costs and the time that was spent in not being paid what was properly owed under the policy. So that's kind of where we are. And I need to talk to the client to see if that is something. I'm sorry, Judge, you're on mute.
No, I'm sorry. Go ahead.
Yeah, so that's really what I need to do is just see if the client wants to move forward. And that's all that.
All right, let me go ahead and give you May 9th. May 9th, 9:30.
Thank you, Your Honor. That's all I have before this honorable court, Your Honor. May I be excused?
Ms. Cowan, anything else?
Nothing further, Your Honor.
Thank you so much.
Y'all have a great morning.
You too. Mr. Davis, what do you have?
Good morning, Judge. I'm here with Fela Olivares on a F0331-228. I think she's on the phone.
All right, Ms. Olivares, is that you on the phone?
Good morning, Your Honor. Yes, it is, Your Honor. The 1919.
Perfect.
We worked out our motion, Your Honor.
Okay,
and
so
we are set to mediate.
All right, so case is going to be mediated with Andrew Almaguer?
Yes.
That was your order previously.
Your Honor, and just to put it on the record, that we were asking the court for the $27,000 to be deposited back, but we worked it out that the lady is the respondent is going to, or actually she's a petitioner, is going to return the half of the money, $13,500, by cashier's check. Mr. Davis, I don't have a date. When?
That's correct. She'll have the check by tomorrow.
Okay. Well, I'll do an order so we can show and reflect on the record that that motion was taken care of.
Sounds good. The court will
And
sign off
signed
on
by
it.
both parties.
Perfect.
All right.
Thank you.
Anything else, Mr. Davis?
No, sir, Judge. Thank you.
Thank you.
Thank you, Your Honor. Have a
Thank you, Ms.
great day.
Olivares. You too.
Bye-bye.
All right. Mr. Nichols, what do you have?
Good morning, Your Honor. How are you?
Good. How are you?
Just fine. Sir, I'm here on cause number CL 21-2142, Ram Mutual Insurance Company versus Ramon Viramontes. And this is a subrogation matter, Your Honor. I represent Ram Mutual, the subrogee of Mr. Gregor Turnwall. And in this matter, I filed my petition and Mr. Viramontes did not answer. So I filed a motion for default judgment. When I did that, Mr. Viramontes filed a pro se answer stating that he wanted to communicate with me and my firm to try to resolve the case and that he takes responsibility for the amounts owed. In the intervening 4 or 5 months, I've emailed the defendant, sent him letters via certified mail that have been received, etc. But I just simply cannot communicate with the defendant. And so I'm filing a motion for this court to order the defendant to communicate with us. I'm just trying to get this case off your docket, sir, without any further pleadings. And if that doesn't work, I'll just file a dispositive motion.
All right. It seems that the court did in fact send notice to Mr. Villamontes.
Yes, sir.
The court is okay with taking a post-answer default against him for his failure to communicate.
Okay.
Maybe we can go ahead and do that by way of just giving him notice of one more of the next setting, because it wasn't
Yes.
set for a default today. But,
Yes, sir, that's correct.
So we can give him notice as long as we all give him notice that it's going to be set for default hearing and it'll be a post-answer default, meaning he hasn't done anything to be in compliance with moving the case along and the court will grant the default.
Okay. Yes,
so-
sir, that would be good for me.
All right, let's do May 2nd.
Yes, sir.
And if you can submit an order setting hearing so that we can put May 2nd in that hearing date and that amount, and then we'll send it off to him. So he gets notice, and if he doesn't appear, and if he doesn't communicate with you, then we'll just take a post-answer default.
Yes, sir. And on May 2nd, it would also be at 9:30, Your
Yes.
Honor.
Yes, 9:30. So please make sure that in the order setting hearing, you include that information, May 2nd, 9:30.
9:30. Okay. Thank you, Your Honor. May I be excused?
You're excused. I'll await that order so that we can send it off, give him notice, and we'll see each other on May 2nd at 9:30.
Yes, Your Honor. Thank you.
Yeah, thank you. Okay. Have Mr. Judge Contreras and Ms. Gonzalez. I don't know if they're on the same case.
Your Honor, good morning.
Good morning. Okay. I know y'all we have a contested case, but we're not here on that one today.
I'm sorry, I didn't hear you, Judge.
I said, I know that both of y'all have a contested case with us, but I don't think we're here on that case. I think you're.
No,
here
we're
on-
not set for today. I got 2 cases, Your Honor. I got a writ on Mark Barron, Your Honor.
Okay, that's
let me
the
get-
CL 220989H, Hidalgo County Sheriff's Office and the state of Texas versus Mark Barron. Vito, are you here on that one?
That's correct, Your Honor.
All right. What are we talking about here, Judge, on this one?
The allegation is theft charge, Your Honor, and the
Okay.
bond is set at 5,000 cash surety, but it's a theft charge, Your Honor. I'm seeking a reduction, Your Honor, to 2,500 cash surety, if possible.
Okay.
Just
Any
a
prior?
reasonable.
I was under the impression it was to be a PR bond, Mr. Gutierrez. I don't, we want to
If you
a PR bond.
get your PR bond, that's fine with me. I
We're
just
fine
don't
with
wanna-
that. Yeah, we're no
Okay.
issue with that.
You're fine with the PR bond?
That's correct, Your Honor.
Okay. All right. Since there's no objection from the state, the court will go ahead and approve a $2,500 PR bond.
Your Honor, I do also have a default case as well. Let me give you that seal number.
I believe that's all the state has. May I be excused?
You're excused. Thank you.
Thank you, Your Honor.
All right, let me go ahead and call CL 211782H, Roberto Rios Perez versus Maria Reina Gutierrez.
And
This is a motion for default judgment against
That's
Maria
correct.
Reina Gutierrez, and are you prepared to go forward?
Your Honor, we've been having problems with the expert on this case, Your Honor. He finally got the documentation, but now he's taking his time. And And I just need a little bit more time. And I know I've been asking the court, and I apologize, but we should get, the next hearing, we should finalize it, a default hearing, Your Honor, with the expert testifying as well. Can we ask for 3 more weeks, Your Honor?
Sure, I
If
can give you a month. I can give you a month, month and a half, whatever it is you need.
Yeah, a month, Your Honor, would be perfect.
All right, May 2nd is the date I'm being given by my staff, May 2nd.
At 9:30 or 9?
9:30, at 9:30.
Thank you so much. That's all I have, Your Honor. Ma'am, excuse.
Your excuse, thank you.
Thank you so much.
Number 6 settled. All right, Ms. Gonzalez, what do you have?
Good morning, Judge. I have F 4971-21-8.
The interest of Aiden Javier Dimas. This was a carryover from, was it Monday?
Yes, Judge. And actually, at that time, you gave us a 2 p.m. setting. However, Odyssey and then the Zoom information was for this morning. I just wanted to let you know, Judge, we are logging in at 2 p.m. But since we were on your 9 o'clock, just wanted to make the announcement.
Okay, no problem. Thank you.
See you then, Judge. Thank you.
too. Okay, Ms. Bettis, it seems that Ms. Ledesma is still in a breakout room with the other case. And if you can just hang tight, you're the last case I have.
Okay, no worries, Judge. I'm here.
I'm here as well, Judge. I'm just monitoring without the video.
Okay, no problem. All right. Ms. Ledesma, were you able to at least maybe get some information that'll help the parties?
I did obtain some information, Your Honor. However, in speaking with the parties, Mr. Garza has a request from the court. I was able to locate the marriage license. However, he wanted to address the court and ask for DNA testing as to the youngest child. I did notify him that the Attorney General's office would oppose any genetic testing since this is a child of the marriage.
Okay, Mr. Garza, again, I go back to, this is the reason why lawyers are always preferred, because requests can be made via motions and, you know, legal arguments can be had. But I'll hear you and I'll see if there's any basis for your request. But again, I understand that sometimes difficulty in financial gets in the way of hiring an attorney, but this is one of those classic examples of you're better off with a lawyer. But
yeah, that's what I'm just realizing. And yeah, it's just, I say the DNA test because we had an issue that had happened. I was at work and I had got home, everything was gone, and she had took off with somebody else. And I did a report on it. I have the case number that she had, I guess, like abandonment of home and stuff like that. So that's when all that comes into place where I want the DNA.
How old is the child?
He's, I believe, 4.
So are we already outside of that window, Ms. Ledesma?
Yes, Your Honor. Ms. Gongora, when did you and Mr. Garza stop living together?
You're on mute, Ms. Gongora.
And the honest truth.
It's already been 3 years.
Okay. Mr. Garza, I'm going to recommend that you hire an attorney if that's something that you want to explore.
Yes, sir.
Okay. And for the time being, I am not going to take action on that request because it's not in writing. And if you really, really want that to be open, you need to visit with a lawyer so that they can explain to you your legal options if you have any, because of the age of the child and because the child was born during the marriage. But visit with an attorney. I can't give you legal advice, and Ms. Ledesma doesn't represent you. Okay?
Yes, sir.
All right. Anything else, Ms. Ledesma, other than the date that we had given you previously of April 27th?
No, Your Honor, I did speak with the parties and I asked them if they would be opposed to an oral trial amendment that would change our pleading from a petition to establish to a petition in suit affecting. Since the parties are currently married, they said that they would not be opposed to that. I also asked as far as an oral motion for consolidation, the Attorney General's office case and the divorce cause. They indicated they would not be opposed, but I will defer to the court, Your Honor.
All right, Mr. Garza, you've heard what Ms. Ledesma has requested or stating. Is that your agreement?
I mean, I'm not quite sure I understand what she's trying to tell me. So, I mean, if you could just break it out to me. I mean, I don't want to say something I don't say agree or with something I don't know. So.
Okay, let me ask you, are you going to be looking to hire an attorney to represent you on the DNA request?
Yes, and as far as everything that's going on.
Yeah, so then let me just do this. How much time do you think you need to do that?
Just give me about just a month would be fine.
Okay, right now, the date that I'm giving you is April 27th. So that's approximately 1 month down the road.
Mm-hmm.
Okay, I can give you a little bit more time to May 2nd if that helps you in any way. And that way you can, I won't take action on Ms. Ledesma's request. Nothing happens today, though. The longer you take, the longer nothing happens today. Okay?
Okay.
Are you okay with that?
Yes, Your Honor. I appreciate it.
May 2nd, 9:30.
May 2nd.
And if you have an attorney, please have that attorney reach out to the court and also give that information, Ms. Ledesma's information to the attorney.
Yes, Your Honor.
All right, we'll see you May 2nd, both of you.
All right, thank you.
Thank you. All right, now let me place Ms. Ledesma in a breakout room with Ms. Vale and Ms. Bettis. All right. Ms. Vale is there, Ms. Bettis, and Ms. Ledesma, if you can go right back into room 6. All right. Any headway?
Yes, Your Honor. They need an order signed by the court that we'll be submitting. My office is getting it ready. It's on the 3 oldest children that we will be doing the genetic testing on, Your Honor. And we'll be submitting that. And as soon as we get that done with, the court signs it, then the AGs can go ahead and arrange it.
So I think that's probably the first step. And I don't, as soon as that order is done and filed with the clerk, please call our office so that we can pull it from the clerk and get it signed ASAP. But if we don't get a phone call, then we won't know to expect it. And sometimes it'll take them a day or two before they forward it to our queue. So.
Okay, that'll be fine, Your Honor.
We'll take care of it immediately.
That'll be fine, Your Honor. And then I think basically, I guess we need either a reset date from the court for these orders. And if the court wants us to, if the court's gonna expect us to go to mediation, I'm just trying to figure it out.
I mean, what are the issues here? I mean, what are we talking about that is so contentious that can't be resolved between two excellent lawyers who have a lot of experience? Talk to me about why you need my help in this.
Judge, it's really about, there's property issues. We got to figure out a way to straighten out a wandering Mexican divorce that's out there also, because you can't have 2 divorce decrees on the same time period. It's just crazy. But yes, there are some things I think that Ms. Pettis and I can resolve. I think there's going to be some issues on property, and there's going to be some issues. There's a home that she wants solely of, that he would like what he's put into at least acknowledge and receive some benefit of that in addition to that.
Why don't we do this? Why don't we, look, a lot of times just getting me into a little breakout room, getting my take on what I think and steering you all in a certain direction, we can have agreements, disagreements, but we can have conversations that doesn't take up a whole, afternoon of, contentious hearings. Why don't we come back in about a week and we can see where we're at, and then let's try to work it out from there. And we can maybe set up a Zoom hearing on a Wednesday or a Tuesday afternoon and see if that's something that we can work out.
That'll be fine, Your Honor.
What do you think, Ms. Pettis?
Yes, Judge, that's fine.
Okay. Okay, let's. What about Friday? Yeah. No, next
This Friday?
Next Friday.
What time?
Well, I have arraignments at 9:30, so I'm thinking maybe 10:30.
Let me just check my calendar, Judge, for next Friday.
That works for me, if it works for Darlene.
We are then talking
April
8th, which should be fine, Your Honor.
Okay. Actually, my staff is telling me that it's not a DWR arraignment, they're regular arraignment, so I could do it at any time in the morning. If doing it a little earlier helps you, we could do it at 9,
That's fine, Your Honor. If you want to do it at 9, you want to do it at 10.
Let's do 9 o'clock on Friday.
Okay, 9 a.m. Friday. Okay.
And that'll just be, it's not going to be a hearing. It's just going to be a Zoom. It'll just be us. It'll just be talking about some of the issues. So y'all get through most of the issues that you anticipate having, and then we'll have a conversation about it that Friday morning.
That'll be fine. Okay. Thank you.
Awesome.
Okay.
All right,
Thank you.
All righty.